All right, welcome everybody to Finance 445. This is the final week, and so we'll wrap up the class this week. We've got a couple things that we need to accomplish tonight. First of all, we need to do a brief review of where we've been, where we're at, what we expect to do this week. Then we need to cover some slides from Chapter 15, which tonight we'll just go over some slides that basically encapsulate the entire chapter. Because this is a very strange course and we only have one chapter worth of material, I've saved the actual book slides from the chapter until this week, and we'll go over those, some of the information, of course, will be repeat information, but it'll be a good, solid review for purposes of the final exam this week. Then, with a good chunk of the time left at the end of class today, we'll make sure to cover the final, right? The information that you'll need to know for the final. So we will go in that order. The first thing we need to do is welcome you to an election night. I'm sure that's why we don't have, all 12 of you here tonight, is because it's an important night historically. We've got a very close election going on with the polls and information coming in. Hopefully something that is interesting. Maybe some of you have gone to the movies or done something else, so you don't have to even pay attention. But a historic election today, and very close election so far as they've come in with results. So we need to talk a little bit about where we've been. So we've had 3 assignments to this point. You had an estate tax assignment from last week, but all 3 of the assignments basically were from the chapter end. They didn't need to be 3 to 5 pages long. We talked about that. We did want you to demonstrate that you had read the chapter and the information in the chapter regarding the question, but as far as getting to some arbitrary page number, I wasn't worried about that. I was just more concerned that you put in the time and effort and energy into making sure that you would get the topics covered adequately. So for example, for last week with the estate tax questions, you could have created a chart or done an Excel sheet, on the information, and come to the tax, but then I would want you to explain through why you put the numbers where you did, and a little bit about, how the process works, like I say, coming from the chapter, and then you'd have been in great shape and gotten full credit. We are still missing a handful of assignments from last week and previous week, so I'm expecting to see some more assignments get turned in this week. Of course, I accept them all the way till Saturday at midnight, so I'd strongly encourage you to get those in and get that done. A couple more things. We don't have an assignment this week. We don't have a discussion board this week, but we do have something different. We have that 15-point course evaluation, and that's really easy points. If you give me some feedback, and of course, the school asks for the constructive feedback to happen in that format because it's not anonymous, right? So just find some positive things that you like so that we can build on those for future courses, and then use your anonymous, course evaluation that maybe you've already done to evaluate me, evaluate the course, evaluate the material, and give us opportunities for improvement, right? Different ways that we can do a little bit better job in future courses with this particular mod. So that's the 15 points. Then the final is significant, right? It's a big test. It's a 3-hour test. Give yourself plenty of time. I think there's something like 78 questions. So as far as tests are concerned online, that's a big test. So just give yourself plenty of time. Make sure you've prepared. The best way, as we've mentioned before, that you can prepare for the test is to do a great job reviewing the chapter material and making sure that you've done a good job going through the material for Chapter 15 before you get to that. The other thing that you can do that I think would strongly help is to have evaluated this session and to write down the topics that I've told you will be on the test, because I'll tell you all the topics that'll be there. And if you'll do that and then read with purpose, through the chapter, looking for those different topics that will be on the test, you'll be in great shape. Still, even if you have done all that preparation, make sure that you give yourself time, right? Don't run out of time on the final. Give yourself plenty of time to do a good job on it. And then, as we discussed in week 1, I accept all work from any weeks all the way up until the end of this week. So if you've missed some discussion board comments, or if you've missed an assignment to this point, or if you haven't taken a test, get in, get it all done by this Saturday at midnight. I can't extend beyond that point. It's a hard cutoff from the school, but I can accept any other late work and give you partial credit for it between now and then. Okay? And if you get stuck on any of it, if you get caught somewhere, make sure and be in touch with me right away so that I can try to help and we can get you on your way. But just know that between myself and Lindsay Haas, we're happy to help. But the minimum expectation for our help is that you've reviewed the chapter, you've reviewed the material, you've listened to the sessions, and then if you get stuck, we're happy to add some insight and help to what you're trying to do. Okay. All right. So, a couple things else. We've got of course our checkpoints this week. Stay consistent with those, and then we've also got like we already talked about, the course evaluation and the test. We don't have any assignment or discussion board from this week. Just a very good week to get caught up and to make sure that you've got everything completed. Okay. All right. So let's go through some slides from chapter 15 and from the book, and then we'll go ahead and spend the balance of the time going over the material that you need to know for the test. And like I say, that'll be a chunk of time because the test is a lot longer and bigger, as you'd expect, because it's a high point. It's worth a lot of points, and it's the final, and it's comprehensive over the entire chapter, as you would expect. Okay. Although many of the questions are repeat questions from previous weeks, so don't get too anxious about the fact that there are so many questions. The bottom line is there's a good chunk of them that are repeat questions from previous weeks. Okay. So let's look through chapter 15 slides according to the book. All right, so what is estate planning? We've talked about it all this month, all this mod, but basically estate planning is planning, right? It's just what it says it is, but it's the planning that establishes how you're going to administer and distribute assets after your death. Okay, and of course that's in accordance with what you want, right? And that could be to charity, it could be to your spouse, it could be to your children, it could be to somebody unrelated. It doesn't matter what you end up doing. What matters is that whatever it is according to your will, right? And I'm not talking about a will that you write, that's part of estate planning, but I'm talking about your desires, what is in your heart, what you want to try to do with the assets that you have, small or large, right? We've talked about estate planning within this chapter and talked about the fact that the book made a big deal when it comes to guardianship and wills and basic estate planning, and saying, look, this isn't just for rich people. This isn't just for folks who have lots and lots of assets. This is for everybody. At some level, there will be estate planning that'll need to be done for everybody, right? Basic funeral costs will have to be arranged. A living will, guardianship if you have children, those things all need to take place. A power of attorney, just in case you become medically incapacitated and need somebody else to make decisions on your behalf. These are things that, whether or not you have children, whether or not you have lots of money, these are things that apply to all of us at some level and can help us out when it comes to transitioning our assets and transitioning, period, into what's inevitable, which is, of course, us passing at some point. Now, this talks about in accordance with the decedent's wishes, right? The person who passed away with their wishes and needs of survivors while minimizing taxes. I would go as far as to say that you could drop off the minimizing taxes part. It still is significant that tax planning, that tax planning can be a significant part of estate planning, but doesn't have to be. Right? Doesn't have to be the main driver of estate planning. Most attorneys sell estate planning based on the tax implications, right? Because that's an easy way to sell it, right? Most people don't want to pay a lot of taxes, so if you sell it that way, it's a way to get people to buy the product that you're selling. But the bottom line is, most everybody has some level of estate planning that needs to be done regardless of whether or not tax planning is the issue. And now that the exclusion that we've talked about in the past is at $5.45 million per person from estate taxes, most of us, right, most of you and I, and I shouldn't speak for you, maybe you guys will be in a different situation, but for me, at least at this stage of my life, I wouldn't I wouldn't need to worry about estate taxes, right? I don't have over $5 million worth of net worth. And so now you know I'm not a multi-millionaire. But the point is, I don't have that type of estate, so I'm not concerned at this point that I would need to have a trust just for purposes of tax planning. It would be more for, the things that I want to have happen, to go to my kids the way I want them to go to charity the way I want them to, so that actually, happens the way that I would like it to. Okay. All right. So that is estate planning. That's the estate planning overview. We have some different problems associated with estates and with estate transitions. And what I want to talk through here just a little bit, we're not going to go through all these, but just wanted to remind you that the book does a very good job of going through potential problems when it comes to estate planning. And not necessarily the planning of estates, but just sometimes the lack of planning, right? So sometimes what happens with our estate, or what happens with our assets after we pass, is just a function of the fact that we didn't do any planning, right? That none of the planning got done, and so we're in a situation where our estates have issues. And a couple of examples are, we don't have any liquidity. Let's say we're a small business owner and we pass away. Our business needs some capital to continue, to hire somebody else to take over, to transition the business, but there's no money, right? We're asset rich and cash poor. So what has to happen? Well, a spouse or the children end up having to do what's called a fire sale, just to sell the business to get cash in order to keep cash flow and wrap up the estate. Well, that sounds okay, but the fact of the matter is you might end up with pennies on the dollar as far as the worth of the company. It might force you to sell a company that really the preference would be to keep it in the family, but you might have to sell it just to make things work. And so you get put in a situation, you get cornered into a situation where your only option really is to sell things that you don't want to have to sell. So that's a problem with lack of liquidity. Or you have a significant estate, right? And there are estate taxes due, and you don't have any ability to pay those estate taxes because there's no liquidity. So the only thing you can do is sell off property, sell off businesses. And once again, those things sell off for pennies on the dollar, and you end up losing significant value to your family based on the fact that you're forced to sell out because there wasn't pre-planning done. Okay. There can be other things. There can be all kinds of different specialty problems. That last paragraph, it starts you down the road of discussing different things that could potentially go wrong with beneficiaries, beneficiary problems, fights, creating discontent and problems, internal strife between siblings. A really good way to create problems in a family is to create a situation where you aren't clear on what your objectives were for your estate. And so when you pass, the children are left to kind of fight over it. Well, that sounds, fine. You're dead. You're not worried about that. But that's a really good way to create problems within a family, is to have, that kind of issue, and to have something vague, not very specific as far as your intentions and where things should go and how things should move. Okay, the more specific you can be, the more you can avoid those types of things. Of course, the book talks about two main aspects of planning, right? The people planning and the asset planning, the actual things when it comes to your assets, right? Whenever we talk about assets, we just mean the things, right? So the issue here is the people planning is really significant. Most people think of estate planning as just an asset planning thing. The reason the book separates them out and really spends a lot of time talking through them is because reality is the people planning part might be perhaps, depending on your situation, but it might be the bigger issue, might be the harder problem to solve. Having family members get what they need but not ruin family members, to create a legacy, things we've talked about on the discussion board throughout the course, those things are very, very difficult and sometimes take pretty complicated planning to make sure that they're going to happen. Okay, so don't forget when we talk about estate planning that we have two different aspects: the people planning and the asset planning. And the asset planning gets all the attention, but the people planning is just as much important or even more important than the assets. Okay, so why does an estate have to break up sometimes? Why do people have to sell off estates or piecemeal out estates? One is there's just costs associated with death. For example, final debts, health insurance, health care many times is expensive final cost. There could be all kinds of other things. There could be legal issues that need to be resolved that cost money to resolve. There's all kinds of death-related costs that can happen. Inflation can create problems for an estate that can break it up because there could be cash there to do some things, and then over time that cash becomes less and less valuable, and in the end they end up needing more than what was anticipated because of inflation, and so they end up having to sell off assets. Another issue, and we talked about it, is lack of liquidity. We gave you an example of the business owner that passes away, and the family has to sell the business for pennies on the dollar because they have to pay final costs and taxes that are due, and they don't have any cash, right? Once again, asset rich, cash poor is a hard situation for estates to have to handle after someone passes away. Improper use of vehicles of transfer. So this is a flowery way. It kind of sounds like we should be talking about like Uber or something here, but what they're really trying to talk about is when we have different assets like IRAs, annuities, real estate. We have all these different assets, and we're trying to use those assets to transfer them to our beneficiaries. Sometimes we don't list beneficiaries. Sometimes we list the wrong beneficiaries. Sometimes we don't do adequate estate planning in order to accomplish what it is that we're trying to do. And so because of that, we get into a situation sometimes where things don't happen the way we would hope that they would happen with our assets. Finally, we can have a situation where we have disabilities, and these could be both mental and physical. You can have Alzheimer's, situations where somebody deals with some Alzheimer's or dementia, and it creates a real problem for their estate because they don't have powers of attorney or guardianship or conservatorship, so that if something were to happen to them, somebody else can make decisions for them. There are all kinds of horror stories when it comes to the elderly getting taken advantage of by their own family, getting taken advantage of by strangers, getting taken advantage of by a lot of people. It's called elder abuse, and it's rampant in this country because what happens is you have somebody who, the generation that's getting old right now and into that mode of potentially dealing with mental capacity issues, is a generation that was very private about their finances, right? Very private about their finances. Because of that, we have a situation where if they're private about their finances and then their finance, and then they get to a point where they are incapacitated or can't really function well with their money, and nobody else has been put in charge of their money, they just put themselves at a significant disadvantage. They put themselves at a significant risk of signing up for something that they shouldn't, doing something that they shouldn't, having somebody take advantage of them. And so one of the reasons that we estate plan is to assume, right, that as we hopefully gracefully transition to our passing, that we won't have this issue, but to plan for the worst, which is at some point we may be at a diminished capacity, either mentally or physically, and we may need family or a trusted friend or a trusted institution to help us to make sure that we don't have problems with our money and with our assets. Something that happens, remarriages, really late remarriages with somebody who's got diminished capacity. I mean, there are all kinds of weird situations that can throw somebody's estate kind of into a tailspin. And then all of a sudden the kids are left looking around saying, hey, dad or mom told us that this is what they wanted to have happen when they died. But now, because of all these changes and people are doing different things with it, we don't know. We don't know what is going to happen. And then that confusion turns into sometimes anger, and that anger sometimes turns into legal proceedings and lawsuits that can last years and years and really ruin the corpus of an estate, and the assets that are there in legal fees and fighting. Okay, so it can get really ugly really fast without basic estate planning. So what are we talking about as far as your estate. The probate estate is all the property that can be transferred by a will. Intestate is if there's no valid will, okay? So if you don't have any valid will, then intestate laws come in, the probate laws come in, and they basically dictate where your estate goes. But you still have a probate estate when it comes to property that you do transfer by will. That's where it's at. So gross estate, when we talk about gross estate, we're just talking about everything, right? Gross estate is everything. And then non-probate estate is the estate that passes other than by a will or intestate. So non-probate could be trust assets, for example, could be life insurance death benefit proceeds, could be annuity death benefit proceeds, could be payable on death proceeds from a bank account, right, that goes directly to a beneficiary contractually. Doesn't need probate, okay, to pass on, because probate has no control over those contractually mandated beneficiary arrangements that I just mentioned. Okay. So what's the process to estate planning? We've talked, about estate planning a lot, but is there a process? What is that process? Well, we've got to assess the family situation, got to set the goals that we have for ourselves. Then we gather all the information that we need. We list out our assets. We designate beneficiaries. We estimate estate costs, and then we come up with a plan. And the plan is not a stagnant plan. It's not right for everybody to have a trust. It's not right for everybody to just have a will. The answer is, depending on your situation, a good estate planning attorney should sit down and go through the process of assessing really what it is that you're trying to accomplish, what kind of assets you have, what kind of special needs situations might be there, and then coming to a conclusion on whether or not there should be some comprehensive estate planning done through different products. There may or may not be, but the answer should be at some level, hey, this planning, right, this preparation and planning for our eventual, passing is a great exercise to get things organized and to do some things that can prevent confusion and problems after we pass away. So what is a will? You'll recall that we've talked about a will, and I always am very careful to say this isn't a living will, right? This is different. Some people get confused because we have terminology like living trusts versus irrevocable trusts. So we have living revocable trusts, and then we have irrevocable trusts. Those are two different things. And then we have wills, and we have living wills. Living wills are medical directives. When we just talk about a will, that's a written legal declaration that basically specifies where property goes. Okay, can be handwritten in most cases. It can be, as long as it's dated and signed and can be authenticated, then it's fine. Most states don't force it to be notarized, although that is helpful when it comes to protecting against problems later. And the book is very careful to list off exactly what has to be present in a valid will. And one of the things that has to be present is you have to have somebody that had capacity to enter into a contract. What does that mean? Well, if you go to someone in the hospital, right, that has just had a stroke, can't speak, really hasn't shown evidence of being able to make cognitive decisions, and you have them put an X on a will that you prepared to give all yourself the assets, you can see whether you could potentially run into problems there. Somebody could contest that, what's called contest that, legally contest it, get a lawyer, and basically disprove the validity of that will, because the parties associated with the will, and in this case the person who's writing the will for their assets, needs to have capacity when it happens. If they no longer have capacity, they technically should not be able to create a will at that point. If they haven't already, it's not going to happen. Okay, so that's something to think of, far in advance of us feeling like we're at risk of some capacity issues. We want to have that done and accomplished before that, well in advance of that happening. But a will is going to declare where things go. And frankly, a will is important also because one of the rules of a will and also of a trust is that both have a legal issue that whichever will or trust is the most recent it supersedes and negates any previous wills or trusts. Okay, most trusts have some kind of wording. Hey, this trust, nullifies and basically makes every other will and trust invalid that was written prior to this date. But actually, federal rule states that that's the case anyway. It doesn't need to be stated, it's assumed that the most recent or current will or trust supersedes and invalidates any previous will or trust. Okay. Okay, what needs to happen with a valid will? You've got those. Then let's assume you don't have a valid will. What happens? Well, then you're in intestacy, which means there's state law that basically determines how your property passes. And we talked about this. Usually it's half to a living spouse and the rest to your children, your biological children. What gets a little bit complicated is if you don't have a spouse or if you don't have biological children or some mixture of all that, and then it can get a little bit more complicated. And each state has rules associated with how that will play out. Okay. Here's what has to be accomplished through a will. Needs to talk about the plan for distributing assets, needs to consider that changes do happen between a family, and needs to be concise, right, in describing. The more vague it is, the more likely it is to be contested or create problems, right? We talked about that a little bit. Common features, you have an introduction clause and go through, and usually you have a witness, but not always required to have one. It's just that if you want it to be more foolproof, and nothing's 100% foolproof, but if you want it to be more likely to be followed, it's a good idea to have a witness. How do you have a valid will? You have to have mental capacity, and we talked about that. You have to have freedom of choice. You can't be unduly influenced, and you have to meet the state's requirements to make sure that it was executed correctly. Okay, so if you do all three of those things, then you've got a will that should be followed. Codicil is when you are changing a will. Okay, things might have changed, and so you're changing it, but you're not writing a new one. You're not invalidating the current one. You're just making an adjustment to the current one. It'd be like an amendment on a trust. Okay, this is like an amendment for a will. Okay, a will can be revoked. So a newer will revokes an older one. A codicil can revoke things associated with a will. And if you burn, tear, or destroy a will for the purpose of destroying it, right, then you will, then it's of course invalid as well. So if I have a will at home and I burn it, then that will, as you could expect, is no longer valid. Here's a sample checklist for executors. Executors are the folks who are going to execute on a will or a trust's wishes, right? It's the person you've appointed to take care of a trust or will. In most cases with a will, it's a spouse or a family member. Same with a trust. Sometimes with a trust, it's a trusted advisor or institution, like a bank, can act as a executor and trustee. So informal memorandum is just a flowery legal way of basically saying you create a letter that you describe what your intentions are, right? So instead of having everything be in a formal will, you can add some intentions. Now, they're not legally binding, okay? But they're nice because they add clarity to a situation if you've passed for your friends and family who might be taking care of your assets, right? And it gives you a list of different things that might be part of that. Courts oversee the probate process, as you can imagine. Executors oversee, a will or a trust. And then we've got some other things that are part of estate planning sometimes. Powers of attorney or POAs. This is if something were to happen to you where you become incapacitated, this is somebody that can act on your behalf, which is much more common than people think. You become hospitalized for a few weeks. Doesn't mean that you're necessarily going to die, but you could be incapacitated for a few weeks and need to still have your financial matters taken care of and bills paid, right? So the issue is we get in a situation where we need somebody who can act on our behalf. And that's where powers of attorney come in. Living wills, as I've described earlier, are basically medical directives. Do we pull the plug or not? Okay, on life support. Durable power of attorney for healthcare. Just somebody that's got the power of attorney, not for financial issues, but just for healthcare issues. Okay, an ethical will just has to do with, it's an informal document. It's basically a flowery language, again, for just writing down basically to your family kind of a letter of what your beliefs were, experiences, what defined your life, your legacy. I would call it more of kind of a legacy statement. This is really neat to have. I think most families would say, yeah, I wish somebody would have written something down like this before they passed away. Some of us don't get a chance to do that, right? We get taken early. But if you just think that this is something could be really impactful and influential to family members going forward. Got two different types of joint ownership that it talks about here. So this is outside of a trust. You've got tenancy in the entirety, which has to be between a married couple, and you've got joint tenancy with rights of survivorship. And JTRS or RWS, joint tenancy with rights of survivorship, is one of the most common ownership types. This is the one where if one of you passes, the ownership gets transferred to the other. Okay, automatically, outside of a trust, outside of probate. These happen outside of any kind of legal issue once you've declared somebody as your survivor beneficiary. Tenancy in common and community property have a need for a will or a trust to dictate where your part of the ownership goes. Okay, these are ownership types that don't automatically happen without a trust or a will. We need a trust or a will to help these pass the way they should. So an example is real estate. If spouses have joint tenancy with rights of survivorship on title for a home, if one of them passes away, the other one becomes automatic owner. It doesn't need to go through a will or a trust. Okay. If it's tenancy in common and they're 50-50 owners between spouses or between friends, their 50% ownership doesn't automatically go anywhere. It has to be dictated by a will or by a trust, or we won't know where it should go. Okay. And probate will have to dictate it. So that's an important concept to keep in mind. Some ownership types automatically transfer property for you without a trust or a will. Other ownerships cannot automatically transfer property. You need a will or a trust on top of the ownership in order to make it happen. So we keep talking about trust, but what is a trust? What's the difference between a will and a trust? A trust, the biggest difference between a trust and a will is that a will dictates where things should go, but probate still is involved, right? It's public information. Probate, just basically probate is there to ensure that the will is followed, right? And then where there's not a will, once again, probate is there to dictate how things should go. A trust is a separate legal entity, okay? A separate legal entity that facilitates the transfer of property outside of probate, okay? A separate legal entity that facilitates the transfer of property outside of probate. It's completely private. Assets can be held beyond death because it's a separate entity that can hold assets. So if you wanted to create a legacy trust, we've talked about those on the discussion board, and accomplish something longer term, that's a way to do it. Where with a will, as soon as you've passed away, the executor's duty is to immediately go through with whatever is intended from the will, right, and be done. And so a trust doesn't have to do things immediately if it doesn't want to. So if you're interested in not just giving your kids a lump sum of money when you die, a trust is a way that you can dictate that and have some more flexibility. So why do people use a trust? There are tax issues associated with it. You can save on taxes. And you can serve and manage your property differently. So how do you pick a trustee for a trust? Well, there's some different ways to do that, but this gives you some lists. The book goes through those. Different kinds of trusts. We talked about living trust, revocable living trust, and irrevocable trust. Irrevocable means just what it sounds like. Once you've done it, it's done. Revocable means once you've done it, you still have the ability to change it and to maintain ownership of it and rights of ownership, which means you could always change your mind later and do something different. Okay. Different kinds of wills, different kinds of trusts. We're not going to go through those. And then we get into gifting, and we talked about gifting quite a bit. We talked about how the gifting rule for this year is $14,000 per person. If you gift split, that's $28,000. Meaning between you and a spouse, you can gift to one person in 1 year up to $28,000 and not pay or file, any kind of gift tax return. Anything more than that, you have to file a gift tax return, and then it reduces your lifetime, the life and death total amount that you can give, right? Which is that $5.45 million that you can give in your combined life and death, either in life and in death. A total of $5.45 million. If you gift more to one person than 14,000 or 28 if you're married, then you're reducing the $5.45 million number. Okay. And so these tables are all outdated now, right? We talked about how the rules have changed over the years. You can see how low they used to be, the thresholds to get credited before you were going to get taxed. Nowadays, it's different. Nowadays, the life and death amount, that $5.45 million, is the total. And you can do it all in life, or you can do it in all death. You can split it up any way you want. But anytime you get over that 5.45, you're going to pay either a gift tax if it's in life, or you're going to pay an estate tax if it's in death. Which we've talked about, estate taxes and gift taxes end up being about 40% on bigger estates. So you end up giving more than a third of your money away if you end up in a situation where you have to pay estate taxes or gift taxes. So that's the motivation for people to use trust planning, to use charitable gift planning, to use lifetime gifts. Instead of 13,000 like this says, it's 14,000 this year. But the point of that is to try to get out of having to pay these real high tax rates on gift and estate taxes. And then you've got what we've talked about before, which is the marital deduction. That's where you can give unlimited amounts to a spouse without paying any taxes, gift or estate taxes. But the problem with that is if you give everything to your spouse, right, and don't have to worry about any of that, if they don't spend it all before they die, then they're going to have the problem when they die, right? Because they're not going to have a spouse to give it all to, theoretically. Maybe they do. But most cases they won't. And if they don't have a spouse to give it to, then they're in a situation where they're going to have to pay the tax at that point. So a lot of trust planning has to do with maybe you giving your $5.45 million and then transferring the rest to your spouse so there's no tax at your death, and then your spouse spending, and then not having more than $5.45 million at their death. So between spouses, you can have about $10.9 million in estate worth and not pay a dime of estate taxes or gift taxes. Okay. Anything more than that, and you start getting in a situation where you've got to do some planning if you want to try to avoid taxation. Last week for the assignment, we did kind of the calculation on estate taxes. Talked about how you get, here's the worksheet that the book shows and walks through, which was last week's assignment. So there's different techniques we talked about on the discussion board. There's dividing and deferring are basically the two main tools. And we've talked about both of those. And then we've also talked about how important insurance, life insurance, is to estate planning and how it can really be one of the very best tools when it comes to creating a good estate plan. A lot of people will ask me my opinion about whole life insurance, universal life insurance, these cash value life insurance policies. And I think in some cases they can work really well. I do think most of them get oversold by agents who are looking for commissions, as you can imagine. And so it becomes kind of problematic. That's why I think people like Dave Ramsey and Susie Ormond say don't ever get cash value life insurance, because they're just concerned that people will get sold and buy something that they shouldn't. My thought process when it comes to estate planning completely changes my opinion about cash value insurance. I think cash value insurance, whole life insurance, universal life insurance, I think those insurances can be one of the best tools that's out there. One of the best, most tax efficient financial tools when it comes to estate planning that there is. The problem is a lot of people, when they're finally ready to do estate planning, they can no longer get life insurance, right? Because they are no longer eligible, their health isn't good enough, or it's just too expensive at that point. So it's one of these weird things where, yes, life insurance is a uniquely good vehicle for estate planning, but most of us aren't thinking about our estate planning until it's too late to get the insurance. So I'd encourage you to think through your estate planning maybe in your 30s and 40s, at the latest in your 50s, and determine if there's some charitable giving that you'd like to do, if there's some issues that you'd like to take care of for your children, or some kind of legacy trust that you'd like to create through life insurance, because life insurance can do those things very well. All right, we've talked enough about the slides. Let's spend some time, as we need to, talking about the test. Okay, as I mentioned, most of the problems on the test are repeats. I shouldn't say most of them. Many of them are repeats, and so you'll recognize some of the problems. Most of the time in this class, well, all the time in this class, all the weekend tests, the assessments that we've had, have basically been comprehensive over the chapter 15 questions, right? They haven't been specific to just the topic that we were covering that week. Almost all of them have been comprehensive to all, of chapter 15. So this is just another test bank test from the book. Basically, it's helping us to look over the entire chapter again, right? So same thing we've been dealing with, just a bigger test than what we've had to this point. And sorry, I'm getting a little bit distracted by the election results. This is crazy. I've spent the last 3 weeks telling customers and clients that we should expect a Clinton victory and what that would mean for the stock market, with my clients. And now we're dealing today with a situation where most of the marketplace assumes that actually Trump is going to win the election today. So a big turn, just crazy. Things are going to be very unsettled tomorrow if Trump wins. As far as the market, I expect the stock market to really lose a lot of points tomorrow if that happens. So that'll be an interesting day. Okay. So let's talk about what's on the test here real quick. I'm only going to do this for about 20 minutes, and then we'll wrap up the class. So I might not get through all the topics, but just know that anything's fair game from chapter 15, and just read through the chapter. Make sure you understand the slides from tonight. Most of these slides should have been repeat information from stuff that you've read already or looked at, because it's information that all came from chapter 15, and that we should have already looked at the chapter multiple times to this point. Number one on the test is a repeat question about the main objectives of estate planning. Just make sure you understand what the book has to say about what the main objectives of estate planning are, and you'll be just fine for number one. Number two, another question, a repeat question about the objectives of estate planning. Number three is a question about the objectives of estate planning. Number four is a question about first-level death-related costs, and number five is a question about second-level death-related costs. What does the book have to say about first-level and second-level death-related costs, and what are some examples of each? You'll be in great shape on those two if you just know the basic difference. And I think both of those, again, are repeat questions from previous weeks. Make sure you understand what is happening with a probate estate, okay? What is a probate estate? How does it happen? We talked about that tonight, but just refresh on that and you'll be in good shape for number 6. Number 7, how often do we need to evaluate changing our estate? How often do we need to do that? And what are some different reasons that we would need to update our estate? Okay, what does the book have to say about that? What are the different potential problems with estate planning? Okay, there's a list that the book goes through. It was one of the first slides that we looked at tonight. What are some of the problems that can happen with estate planning, and how do you solve those? You'll be in good shape on number 8. Number 9, you need to know the difference between people and asset planning for number 9. What is the difference between people and asset planning? Number 10, need to know about other problems of estate planning that we just barely talked about. Okay. Number 11, want to know what the reasoning is for custodial accounts. I think this is once again a repeat question from previous weeks, but what are custodial accounts for children, for minor children? Number 12 is another first level, second level death-related cost question. Number 13, what is an estate breakup? How is it caused? What does it mean to have an estate breakup? We talked about that tonight a little bit. Talked about life insurance as a tool for estate planning. What can it What can it do for an estate? Obviously, life insurance as a tool can solve some of the problems that we're looking at here on this slide, on this graphic. Can create the income or liquidity that we need in order to dispose of our assets in a good way. Number 15 is another question about probate estate. What is probate estate? How does it work? Number 16. Number 16 is a repeat question about how complicated estate planning is based on having property in different states. There are federal laws when it comes to estate planning, but then there are also state laws, right? So the more states that you have property, the more complicated that your estate planning is going to be, and that's pretty intuitive. So number 16 on the test should be pretty easy. It's also, like I say, a repeat question as well. Number 17, once again, problems of estate planning, improper vehicles of transfer. This is one that we talked about a little bit. Make sure you understand what the chapter has to say about improper vehicles of transfer. And we talked about how it sounds like we're talking about something like Uber, but really we're talking about different products and things that we use to transfer our estate that aren't going to work, okay? That don't turn out the way we intend them to. Number 18, we want to know the examples of different reasons for estate breakups, and if we know that, then we'll be in good shape for that one. Number 19 on the test is another life insurance as it relates to estate planning question. Number 20 on the test is estate taxes, how they're assessed. So think back to last week. How do estate taxes get assessed on our money? And then look through the chapter, what the chapter has to say about that. Number 21, what is an ILIT or an irrevocable life insurance trust? How is it used? Why is it an estate planning tool? ILITs. What is a will? Number 22, pretty straightforward, just definition of a will. Number 23. Number 23 just has to do with, what the book has to say about disposition of assets, right? So what is the point of making sure that your assets are disposed, or have a orderly disposition, right? And that one's a pretty straightforward one on 23 if you've read the chapter. Number 24, you'll want to know the parts of a last will and testament. What are the necessary parts of a last will and testament? Number 25 asks us if we die without a will, what's going to happen? What is that called? What is it called when we die without a will? Number 26 asks us, what does the book have to say about probate? Who among your family members, and we talked about this tonight, who among your family members is going to benefit most if probate takes care of your estate? Okay. Where do most of your assets go through? If you're married, okay, there's your hint. If you're married, where do most of your assets go if probate takes care of your estate because you don't have a will? Number 27, another related question. What does the book have to say about where your assets will go? Okay, how does it get divided out between family members? And we talked about that tonight, but just remind yourself from the book where money goes when probate is taking care of it. Number 28, what happens if you die intestate? What happens with your assets? Number 29, what are the requirements of a valid will? Just make sure you can list out the requirements of a valid will. Number 30, what does the book have to say about choosing guardianship? Okay. What does the book have to say about choosing guardianship? Number 31, who is the person who writes the will? Okay, there are different terminology for, like executor, trustee, testator, probator, grantor, all these are estate planning terms. Just know basically what, who's who, and you'll get that one right. Number 32 on the test, who writes a will? And we've talked about that tonight. Who's the one that's going to help you write a will or a trust? What type of professional does that? Pretty straightforward. Number 33 is just another requirements of a valid will. Number 34 is requirements of a valid will. Make sure you understand what is required for a valid will, then you'll be able to identify things that aren't required, right, with those types of questions. Number 35, what are the rights of a testator with a will? What rights do they have? What does the book have to say about that? Number 36, what is a letter of last instructions? What kinds of things can it have? Remember we talked about how it's not legal, it's not a legal document, it's just kind of an informal list of things that you think are important to have happen and can be very helpful to those people who are trying to take care of your assets for you and fulfill your wishes. But the book also gives you a list of different things that potentially could be part of that, so that's something to consider. Another question on 37 about letter of last instructions. Examples of letters, what a letter of last instructions could have as part of it. Number 38, once again, executors, administrators, testators. You'll need to know the difference between those folks for number 38, what kind of role they have when it comes to a will. Number 39, just define what a gross estate is, and you'll be good on that one. What is a gross estate? Number 40, if you know how to define it for 39, if you know basically what it is for 40 and 41, you'll be in good shape. Both questions ask true-false questions about what a gross estate really includes and what it doesn't include. Number 42 is just an estate planning process question. So what does the book have to say about updating your estate? What does it say about updating your estate, whether or not you should or shouldn't, whether or not, how often you should, those types of things. Number 43. Number 43 is false. It's kind of a tricky question about adoption. So if you've listened through the session to this point, you've got one right. Number 43 is false. Number 44, what does it mean to die intestate? This is another repeat question, just asked in a different way. Number 45 asks about what makes one estate plan good versus another. We talked about that a little bit tonight, or I alluded to that. I told you that one estate plan to another can look very, very different. There's not one type of estate plan that's better than another. What makes one good over another is just that it accomplishes exactly what it is that you're trying to accomplish, right? So one person needs a whole different type of estate plan and a whole different lineup of products than the next person because their situation is different, right? Their goals, objectives, family situation, assets, all those things are different from person to person. And so that's what dictates that the plans look different, but it's only as good as it takes care of your goals and your unique situation. Number 46 is a repeat question. I recall this from a previous test asking whether or not wills are required by law. Make sure you know the answer to that question before you get to 46. Number 47, intestacy, what does that mean? Number 48, what does it mean to have a valid will? Make sure you understand for 48 that no matter how good you do estate planning, no matter how great your will is, no matter how great your trust is, people can still contest it, right? They can still fight it. They can still go to court over it. Even if your trust, and I've seen a lot of trusts that say something like to the effect of, if anybody contests this trust, if any of my beneficiaries contest this trust, meaning their children, they get nothing. Okay? So that's an interesting thing to say, and some children might be a little bit more reluctant to bring a lawsuit if they see that kind of wording. But the fact of the matter is if they have a legitimate bone to pick with the trust or with a will, then and they're willing to pay an attorney, the attorney's willing to fight, right? And anytime there's a fight, there's always a chance to lose. Even if the odds are stacked against you, there's a chance, right? And so just be aware that no matter how well you do your estate planning, there's always a chance that somebody in the family or one of the beneficiaries contests, and brings suit against it for many different reasons, right? And it doesn't mean that they'll win, but just be aware that that could happen. Number 49 is true. Number 49 is the interesting question about about what spouses are entitled to. And basically, this goes back to community property states. In a lot of states that are community property states, if a spouse passes, they might even be entitled to more than what a will even granted them, just because of, by virtue of the fact that they're the spouse. Okay, so that's number 49. Number 50, this is where I think we'll wrap up tonight. Number 50 asks about what is a good way of protecting your documents, like your will. And of course, the book is going to give some suggestions on how to do that. And I would just make sure I understood before I got to the test what those suggestions are. Because it could be, one thing, they could say one thing on Google, right? If you Googled, how should I keep my will safe? Whatever. But make sure you understand what the chapter has to say about what they would suggest that you do with your will to make sure and keep it safe, so that it doesn't get destroyed or stolen or something like that. Okay? All right, so that's 50 of the questions on the test. Just review the chapter. The chapter has all the information that's going to be on the test. The test is a test bank of questions specifically from chapter 15. So look through the chapter, make sure and review it, study it, and then you should be in great shape for the test. If you have any problems or concerns or get stuck on anything this week, let me know. Good luck as you wrap things up, and good luck with the course, and I wish you the best in your next course and getting your degree. Have a great night, and we'll talk to you later.